Gentlemen, both sides ready to proceed?
Yes, Your Honor.
All right, you each will have 15 minutes, and the appellant may reserve up to 5.
May it please the court, my name is Mike Stiff. I represent appellant Firestone veterans of Florida, or post 3383, and I would like to reserve that 5 minutes.
Thank you.
Appellant owns real property, the VFW owns real property, including a hall and picnic grounds. The VFW's rental contracts show that both are available for rent, and that both rental contracts require refundable reservation deposits. Deposits for hall rental are refunded for reservations canceled more than 30 days prior to the rental date. Deposits for picnic ground rentals are refunded after use of the picnic grounds upon verification of the absence of property damage. In December 2013, the VFW applied for exemption of its real property from taxation for tax year 2013 on grounds that the VFW met the requirements for exemption set forth for veterans organizations under the Ohio Revised Code. Those requirements are that the veterans organization hold an IRS 501c 19 or 23 status, and that the rental income does not exceed, quote, $36,000 in the tax year before accounting for any cost or expense incurred in the production of that income, close quote. In October 2014, the Tax Commissioner of Ohio, whom I'll refer to as the Commissioner, confirmed the VFW's 501c 19 status, but denied the VFW's application on the sole grounds that the VFW's gross real property rental income exceeded the statutory $36,000 threshold. The VFW appealed to the Ohio Board of Tax Appeals, the BTA. The VFW's appeal included a copy of a complete notice of appeal to the Board of Tax Appeals form and a cover letter. The cover letter stated, in part, quote, "We have enclosed a copy of our 2012 and 2013 amended tax returns. It shows the rental deposit refund amounts that we issued for the 2 tax years in question. We would ask that you reverse your final determination," close quote. Instead, in March 2015, the BTA affirmed the Tax Commissioner's denial of the VFW's application. The BTA's decision states, in pertinent part, at the board's hearing, Byron Morris, appellant's quartermaster, testified that the refunded deposits bring the total income below the $36,000 statutory threshold. In response, counsel for the Commissioner argued that the threshold refers to gross income, not income less expenses, i.e. deposit refunds. The Commissioner's argument equates deposit refunds to expenses, a characterization that would require inclusion of deposit refunds as gross income, though they could be deducted later as expenses. In other words, the Commissioner argued that refunded deposits were income. Clearly, in response to that argument, and despite Mr. Morris's uncontroverted testimony to the contrary, the BTA treated the refunded rental deposits as part of the VFW's real property gross income, and then ruled that the VFW's gross rental income exceeded the statutory threshold. We are here because refundable deposits are not income. The BTA should not have counted the refunded deposits as part of the VFW's rental income. The Commissioner got it wrong. He represented it to the BTA wrong, and the BTA got it wrong. According to no less than the United States Supreme Court, the United States Tax Court, the 8th District Court of Appeals, and several tax treatises, sums deposited as security for a lessee's performance of the terms of a lease are not taxable income on receipt. That's the John Mantell case, which I've briefed. This is a fundamental accounting principle of common law, that a deposit is not income to the recipient, but instead constitutes a debt owed by the recipient. Those are the words of Knight versus Ford Motor at our Ohio's 8th Appellate District. The court goes on to hold that a security deposit creates a security interest, i.e. a pledge, would derogate the common law principle that a security deposit instead creates only a debt. Even our nation's highest court has commented on this issue, saying that for deposits to be taxable income, a taxpayer must exercise complete dominion over the deposits. In Commissioner of Internal Revenue versus Indianapolis Bar and Light, which is briefed, it states, even our nation's highest court, the key is whether the taxpayer has some guarantee that he will be allowed to keep the money. It says held. Although the taxpayer derives some economic benefit from the deposits, it does not have the requisite complete dominion over them at the time they are made. The construction is consistent with the tax court's long-standing treatment of sums deposited to secure a tenant's performance of a lease agreement, perhaps the closest analogy to the present situation. That's 110 Supreme Court 590. The BTA's decision relies on gross rental income figures that include refundable rental deposits. The VFW's tax returns state the amounts of refunded rental deposits. The returns show that those deposits were erroneously included as part of the gross rental income entries on those returns. This error was brought to the BTA's attention through Mr. Morris's testimony.
Was that so with regard to just the initial filing with the IRS, or wasn't that repeated in the amended filing?
It was, Your Honor. It was repeated in the amended return prepared by the VFW's tax preparer. However, Your Honor, as much as I would fault the tax preparer in doing so, I have to note that the Commissioner's own counsel, or the Commissioner himself, at the BTA hearing testified that refundable deposits were income. So even the tax commissioner got it wrong. The returns showed that those deposits were erroneously included as part, those deposits were erroneously included as part of the gross income entries. This error was brought to the BTA's attention, but was ignored in deference to the cited erroneous argument raised on the Commissioner's behalf. It was unreasonable for the BTA to accept the Commissioner's erroneous argument. It was unreasonable for the Commissioner to make such an erroneous argument during a BTA proceeding. It was unreasonable for the BTA to reject the VFW's uncontroverted testimony. It was unreasonable and unlawful for the BTA to deny the VFW's real property tax exemption application.
Counsel, I'm concerned about what it is that you're asking this court to hold and what the implications will be beyond this case. I understand the argument that you're making here, but what will be the implications if we adopt your position and say, in a situation where a taxpayer, whether it be private or public, files a return, brings that return before the tax commissioner and invites the tax commissioner to rely on that, and then corrects it and brings an amended return, which is still not correct, that somehow it is the tax commissioner's obligation to go beyond that, and it puts the onus on them. What are we inviting citizens to do in terms of their responsibility in correctly filing their tax returns?
Well, admittedly, and I appreciate your concern, Your Honor, the court should be concerned about some precedents in that regard. However, there are a couple differences here. One is that the tax returns are supposed to be read as a whole. One must see that this entry is not seen as something important to the VFW at the time. The tax preparer did exclude the income, but used it as a deduction rather than as an exclusion of income. And I always look to the argument. Had the argument been at the BTA, had the statement been made, well, refundable deposits are not income. If the correct statement of the law had been made, then this would be completely different. Actually, the BTA, I feel, would have ruled otherwise. So I see this case as a particular exception.
And Council, you just have 5 minutes remaining.
Thank you.
May it please the court. There are actually some jurisdictional issues here as well as substantive issues, and I'd like to briefly talk about those. The first one was actually the subject of a written motion to dismiss, and that has to do... Yes, Your Honor. I'm with the Attorney General's office, and thank you. It's a pleasure to be here. I had a nice trip from Columbus this morning. It was very nice of the court to schedule 11:30. The jurisdictional issues are actually twofold, but the first one I'd like to talk about is the certified mail requirement that service of the notice of appeal must be made by certified mail on the counsel of record for the tax commissioner. This court preliminarily determined that that wasn't a jurisdictional problem, but invited in its decision further discussion on that. So I'd just like to focus on that just real briefly. Actually, what was stated in this court's order on this was that the commissioner conceded that there was service on the commissioner. Actually, no, that's the nub of this. The statute that sets forth the appeal rights from the Board of Tax Appeals to this court says that the commissioner has to be served. But how the commissioner is served is determined by the Court of Appeals Rule 1. It says that counsel of record must be served. And I was counsel of record below as well before the Board of Tax Appeals. And the Board of Tax Appeals has its own rule that when the commissioner or any party is represented by counsel, then service of all pleadings must be on that counsel. And we do rely on this Swander Ditch case, which is a Ohio Supreme Court case that Chief Justice Moyer authored. That case actually was much more difficult because in that case, the administrative agency from which the appeal was made, the appeal was to the common police court, and the common police court did not have any express rule that said the administrative agency must be served through its counsel. Whereas here, we do have the Court of Appeals rule. There's no tension between the 5717.04, which is the Revised Code provision, providing for an appeal to this court from the Board of Tax Appeals, and Appellate Rule 1. And I would say, I've been doing this now for over 30 years for the Commissioner, representing for the Attorney General's office. And this is really the first case I've ever seen where counsel did not serve the Commissioner's counsel. And sometimes they serve both. They serve the tax commissioner at their address and the counsel of record, which is the Attorney General's office, in this case, me. And you can look at the Supreme Court's website because they have all their appeals from the tax commissioner, and you'll see in every instance where the court has accepted jurisdiction, there's been counsel that's been served, that is the tax commissioner's counsel, the Attorney General's office, taxation section. In each case, in my entire career, where, now there are situations when certified mail service isn't done, it's by ordinary mail, and there's a legion of cases that say, even when the tax commissioner's counsel is served and timely, if it's by ordinary mail, not certified mail, then it's jurisdictional. This is a much worse violation. We didn't get anything at all. Okay, now I'd like to move to the second jurisdictional point. And Judge Moore, you, I think, really clearly articulated the concerns that this case has, and there's jurisdictional ones. If you look at the Notice of Appeal to the Board of Tax Appeals, basically it was filed and said, we object to the Commissioner's failure to grant the exemption, see the tax returns that are attached. So they were expressly relying on the tax returns. Now they're pulling the rug from under us, or baiting and switching us, and saying, no, don't trust our return. In their notice of appeal to this court, they made a completely different argument than what they argued before the Board of Tax Appeals and what they had raised in their notice of appeal to the board. We cite several Ohio Supreme Court decisions that say new issues can't be raised on appeal from the Board of Tax Appeals. The taxpayer is bound by the specification of error set forth in their notice of appeal to the board. And I brought with me a very recent decision that cites the cases that we cited. And I have copies for everyone if that would be appropriate to give now.
Did you file that with?
I didn't, Your Honor, but again, this is what we did to economize. In my response brief on the merits, I addressed their newly raised issues. I could file a separate motion to dismiss if I wanted to. But also, I mean, the cases that we already cited are cited in the most recent case.
Well, I'm not saying you can't do it. All I'm saying is you need to follow.
I'd be glad to do
procedure
that.
And file a motion to.
Absolutely.
To file a supplemental brief, and then we'll roll in and give.
Absolutely.
Opposing counsel.
And that would be perfect. Thank you. But with respect to the jurisdictional issues, we cited the global knowledge case and several other cases that stand for the proposition that newly raised issues pursuant to notice of appeal from the board's decision can't be considered because they're jurisdictionally barred. There was a requirement to have raised those earlier. Now, when we move to the merits of this case, the argument is made that in fact the gross rental income figures were incorrect as disclosed by the taxpayer, and then that they should have been reduced by the amounts of rental deposits that were returned. But other than knowing that there are rental deposits, there was no testimony about the nature of those rental deposits. For the first time, even in the briefing, my distinguished colleague says things in oral argument here that he didn't even say in his briefing about the nature of those deposits and under what conditions they're returnable. Now, we do know the statement that Byron, the quartermaster, made in this case, who appeared at the Board of Tax Appeals. He said that he understood that the gross rental income, the rental income included all the amounts that were paid, including the amounts that were advance payments that were these deposits. That's what he said. But then, and that's consistent with the returns that were filed. But then his position was that it's proper to net those, to take the total income, including the advance payments is what I would call them, the rental deposits, and then when those rental deposits are returned perhaps in the next year, they're an expense in the year that they're returned. Now, we don't know under what conditions those rental deposits were or were not returnable. But we do know that for federal income tax purposes, they disclosed under penalty of perjury that the proper treatment was as expenses. And we do know that there are several facts and circumstances under which rental deposits are properly treated as income when received, and then if they're returned at some later point, they're deducted as expenses. We know that from a bunch of cases that we cite in our briefing, including the Annapolis Power case, the Synergy case, and several other federal circuit court decisions. It's called the claim of right doctrine, that when somebody receives something and they have a right to it, but there may be conditions where they have to return it, and nonetheless it's income in the year in which they receive it, and then if they have to return it later, then it's expensed in the later period. And that's precisely what we have in this case. If we reach the merits of it and we ignore the fact that the returns themselves say what we believe is the proper treatment and the proper law. There's absolutely nothing in this record, and it was certainly the taxpayer's burden. We know this is to establish entitlement to the exemption. And it would be a strange state of affairs if a taxpayer could pull the rug like this in a case and completely change and disavow its express statements that are made under penalty of perjury for federal income tax purposes. And as we know, this can't be characterized as a mere mistake in terms of inadvertent, because the only difference between the originally filed federal income tax return and the amended return is that the amount of gross income that was set forth in the original return was just the amount that it didn't expressly, it was amounts over $36,000, which is the threshold amount. And there was no rental, there's no offsetting expense. what they did in the amended return, it's identical in every other way, except they took the security deposits that were returned and put them as rental expenses. So clearly, it was the position. That was the only reason to file the amended returns, was to show that, in fact, the rental deposits were, the return of the rental deposits was a rental expense, and that the original receipt of those deposits was, in fact, income. That's precisely why they filed their amended return.
Well, if we assume that the VFW just, had a tax preparer who didn't exactly know what he or she was doing, that would have implications for the taxable years of, is it 2012 and 2013? Is that what we're?
That's right, you're right, Your Honor.
Is there anything to preclude them from going forward, seeking an exemption for the?
Absolutely, Your Honor. It's an every year determination. So the only 2 years we have at issue here are 2012 and 2013. Going forward, it's a brand new ballgame. And frankly, I've encouraged, I can't represent them, but I've encouraged them, and I think Mr. Steth would agree with me graciously that, I said, hey, you ought to apply, don't be discouraged about applying for more current years. Because, it's a $36,000 amount, and every year's different. So, and they were very close to the threshold. Now, I would say that one of the things that we did when we looked at the return, we didn't look any further than the originally filed return, that was the returns for those 2 years, and the amended returns. I didn't look at anything else because that was slam dunk, we win. But there could be other things that I would have looked at. For example, if you look at their total rentals, they're actually well above. They have oil and gas rates that may be implicated here. If you look at their total rental income, it actually could be in the 40,000s, not the amounts. I didn't look into any of that because I didn't need to, and I think that was appropriate. If there are any further questions, I'd be glad to entertain them.
Evidently not, thank you.
Thank you.
May it please the court. The counsel for the commissioner talked about certified mail. I recall his motion on the matter. It was clearly listed as a jurisdictional motion. I pointed out by brief that all the jurisdictional requirements were covered by the statute. Each and every one was met. He then argued that the rules of procedure applied, which perhaps they do, but it was not a jurisdictional issue. It was a procedural issue. I stated in the brief that counsel for the tax commissioner was in telephone contact with me within 5 days of filing the notice of appeal. There was certainly no prejudice involved, and it was procedural. It was not jurisdictional. Regarding, counsel said that this was a first-time argument, that the argument was completely changed. Actually, the security deposits being counted erroneously on gross income were covered and stated in the BTA decision. The BTA decision stated Mr. Morris's testimony as, quote, he testified, quote, that the refunded deposits bring the total income below the $36,000 statutory threshold, close quote. Now, Mr. Morris's statement was and is that the deposits are not income and should bring down the income figures. The only one who argued or contended that refunded deposits are income was the commissioner himself, through counsel who erroneously argued that deposit refunds are income. There was mention in council's argument about signing tax returns under penalty of perjury. Well, Mr. Morris addressed the returns erroneous gross rental income entries. And as said, he testified that the refunded deposits bring the total income below the $36,000 statutory threshold. The idea that an entry on a tax return somehow places the individual truly under penalty of perjury when, if the return were read as a whole, everything has been provided in the return, it just doesn't, I just don't fathom that. The commissioner's argument has been that the BTA is jurisdictionally barred, or the BTA was jurisdictionally barred from reviewing this matter. And if I understand it correctly, a supplemental brief is going to be submitted on that topic on the basis of the new case.
I don't know, I've not seen it, but it's my understanding that he has something to file with the court, yes.
Well, I guess that I should hope that he does, or the court should, because I'd like to point out that the commissioner's argument repeatedly uses the word specify. He claims that that there was a requirement that the VFW specify the error complained of. And that's because the reference statute used to state errors complained of must be specified. You see that in the cases that were cited by counsel, such as Queen City Valves. That case even goes to Blacks to define the word specify. Every one of the commissioner's cases relies upon an earlier version of the law, and a much more restrictive one. The law was amended in October 11, 2013. And it no longer requires that the claimed error be specified. This less restrictive version of the statute was met by the notice of appeal. Again, the statement that was made was, these are refundable deposits. That is a statement that these items, that these amounts were not income.
And counsel, you have time.
Thank you.
Thank you.
Thank you.
Thank you to both sides. The court will take the matter under advisement and issue a written opinion, and that will be sent to you, as well as we will release it on our websites as well. So thank you, have a good day.